and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie.
We are here to talk about an upper tribunal case from the end of March, 27th of March, and the case is called Kirkman and Bradshaw Pub Company Limited. And it relates to adverse possession, which is timely because we've just done a course on adverse possession too. But do you want to start, for those of people who didn't come to the course, with a bit of a summary on the law of adverse possession?
Yeah, well, it's complicated and cases tend to depend on their facts. But the basic idea is that if you can show the requisite time period, you might be able to make a claim for adverse possession. You've got to show if the claim arose in registered land before October the 13th, 2003, when the 2002 Land Registration Act came in, you can claim after 12 years adverse possession. In an unregistered land, it remains 12 years on adverse possession. If the claim arose from October the 13th, 2003, the 50th birthday of the then Chief Land Registrar, if you remember, then, you can make a claim after 10 years, but if the claim is resisted and there's a counter notice, you have to show one or more of three types of adverse possession, most notably where you've made a reasonable mistake as to boundaries. This was a claim, registered land claim prior to October 2003 that already got the 12 years adverse possession. So I've steered clear of the post-2003 registered land situation. And you could spend ages on this, and I won't. But to claim adverse possession, the paper owner has to have ceased using the land or been dispossessed from the land. I remember somebody asking me, if the paper owner is still using the land, can you claim adverse possession? Well, no, you can't. It's got to be dispossession or discontinuous use. And it's got to be, if you remember, Lizzie, there's got to be a degree of factual possession, a corpus possessionis, as they say in the old cases, and an intention to possess the land, an animus possidendi. They didn't say that in this case, but in some of the older cases, an intention to occupy. So that's some of the background as to the law.
So do you want to tell us a bit about this particular case then and the background facts of it?
Yeah, it all took place in West Yorkshire, somewhere to the west of Bradford. It was all sort of set on a long lane, which was primarily going through countryside. But somewhere in the lane, there was a pub and 30 cottages that had been there for, it seems, quite a long time, a very long time, stone cottages, and some other larger houses by as well. So a little hamlet, really, and seems like in the middle of nowhere, but somewhere not far from Bradford. What had basically happened, the land involved was there was a wash house, a privy. You know what a privy is?
We all have wash houses and privies, obviously.
Like in Bristol, but people did in the past. An outdoor loo and a wash house, which seemed to be in communal for these cottages back in the day. And also an ashes place. But you don't know what that is.
No, I don't.
I didn't either, but it's apparently where the locals would dump their ashes from coal burning, from fires and things like that.
Oh, okay.
But ashes place, I thought it sounded quite nice. I thought it was like ash trees and things like that, but it's not. And also between the wash house and the privy, the wash house was pretty small. It was something like 5.01 meters by 3-point-something meters. And there was for want of a better expression, between the wash house and the privy, there was a yard, which was only 2.58 meters, which is, give you an idea, it's not much wider than a normal car parking space. So not a huge piece of land. And what had happened is that back in 1987, it was number 3. It was called, I should have told you this earlier, but it was called Wellheads was the road. And number 3, Wellheads, had been registered, and the then owner was registered with the benefit of the the privy and the wash house and the Ashes Place. At a later stage in 1988, Mr. Kirkman had been registered, well, him and his wife, but his wife didn't take part in the final case, the upper tribunal decision. Mr. Kirkman had been registered as proprietor of number 12 wellheads and also the privy. He had his own personal privy, but not the wash house and not Ashes Place and not the yard. Going fast forward in 2019, the Bradshaw Pub Company purchased number 3 and the Ashes Place and the wash house and this little bit of yard. But what then happened is Mr. Kirkman claimed the right to adverse possession. The Bradshaw Pub wasn't a pub. It was being purchased. Well, there was a Bradshaw Pub Company, but this particular land had been purchased for a holiday let to be used for short-term holidays in the area. And I say he makes a claim for adverse possession over this land based on more than 12 years user from 1988 onwards.
So what was the decision?
Well, part of the first instance decision was from May of last year. Part of it stood, but the other part didn't. As I mentioned, you've got to show a factual possession of the land and an intention to possess the land. Factual possession is basically you're treating the land. They quoted from a case called Powell and McFarlane from 1979, which was confirmed by the most important case, certainly in recent years, Pyam Graham, a House of Lords case from 2002, that you sort of separate into these two areas. They didn't express it quite like this, but I prefer my words. But it was factual possession, as you're basically treating the land as if it's your own land. You're doing on that land what you would do if it's your own land. And lots of cases, including Powell and McFarlane, made clear in the past that depends on the nature of the land. For instance, in Powell and McFarlane, all they were doing on the land was they were maintaining existing fences, clearing, so there were weeds and brambles and the likes, and also grazing animals. And on the facts, that wasn't enough. It wasn't mentioned in the report on this decision, but there was a case, for instance, Red House Farms in Catchpole, 1977, I think, from Norfolk, where it was boggy marshland, pretty unsuitable for grazing likes, and what they were doing, Catchpole was based his adverse possession successful claim on shooting. It didn't say what they were shooting, but shooting on this marshland. So it depends on that, and it also depends on the manner of use of the land, what would be commonly expected type of use for that land. And there are lots of cases, as I say, that would depend on the facts. But secondly, you have to have an intention to possess the land, an intention to exclude all others. Again, you don't have to think it's your land, but you intend to exclude all others, including the paper owner from the land. And cases galore over the years, this is basically what this was about, have said that a strong evidence of the intention to exclude others is fencing and, locked gates and this kind of thing. And that's basically what it was all about.
So what was the ultimate decision on this one?
Well, in terms of the wash house, what seems to have happened, it was accepted as fact, is that back in 1988, when Mr. Kirkman had bought this number 12, he'd been given a key to the wash house. He didn't think anybody else had a key to the wash house. There was evidence from neighbours that he was storing things in the wash house. What, we don't know. And also, he was removing brambles from around the wash house and paying the electricity bill was the other thing. So the first instance, the first tier tribunal and the upper tribunal agreed that's evidence of adverse possession. You're excluding all others, you're factually possessing the land. But the major thing, an issue, was this little bit of yard. There's 2.58 metre wide piece of yard, an Ashes Place. It seemed to back onto it. The wash house, there was clear adverse possession, factual possession and intention to possess the land. But the first instance, the first tier tribunal decided, because there was no fencing amongst other things in relation to this little bit of yard in the Ashes place, there couldn't be an adverse possession claim. And that's where the upper tribunal disagreed. They said that you can't compartmentalize the various areas. You've got to look at the whole, if you like. And if there's good reasons for not fencing, then you don't have to fence. They quoted a case called Pilford and Green Manor, and from 2012 Court of Appeal case, which is not the best case on it, actually. There's a lot of cases they could have quoted, which say otherwise. But if there's a good reason for not fencing, you don't have to fence. And there's lots of cases on that over time. Shall I mention another one of them, which wasn't mentioned in the case?
Why not?
There's a case called Thorpe and Frank, a Court of Appeal case from 2019, which doesn't seem to have been discussed, where it was a couple of 1960s semi-detached houses, which were open plan. They got restrictive covenants against putting fencing up. And I think for quite a long time, predecessors of Thorpe and Frank had assumed that part of the land, which should have been in the title of Frank's, was actually in the title of Thorpe. Well, people thought it was in the title of Thorpe because there seems to have been a kink, it didn't run flush with the front, where your boundary of your house was. And the court in that case decided there was restrictive covenants and the likes that meant you couldn't put a fence up. And therefore there was good reasons for not fencing. And in this particular case, they basically said that the only stretch of the land which wasn't enclosed, the sort of two outbuildings, the wash house and the privy, sort of partly enclosed the land. There was some fencing, but there wasn't any fencing or a gate as you got onto the road, onto the lane. And the upper tribunal decided there's very good reasons for not fencing. It's a tiny piece of land. If you put a gate there, then you wouldn't be able to open the gate without kind of blocking the doorway into either the privy or the wash house. So it's one of quite a few cases that say over the years that fencing is desirable in terms of adverse possession, but if there's good reasons not to fence, you don't have to fence. I told you that when I came across, in the course that in Exmoor, where it was originally rejected a claim when it was only fenced on three sides, when the fourth side was a 250-foot cliff into the sea. And that's a good reason for not fencing. So that was it. There was a successful adverse possession claim. Amazing how many cases there were on adverse possession. But there you are.
Thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.